An important consideration is for us to look to see when someone dies, what is the responsibility of the police, and of course, what is the responsibility for us as citizens. There is laws of Guyana that every unnatural death must be investigated. In this sense, today we want to talk about the coroner and who is a coroner. We can look at the laws of Guyana and we look at chapter 4:03, which is the Coroner's Act, which speaks to the entire setting up of an inquest or an inquiry. Now, who is a coroner? A coroner will be a magistrate, or of course, which is from a magisterial district, particular magisterial district, or a justice of peace who is, law provides, is an a coroner. What is an unnatural death? The laws of Guyana, the Coroner's Act, has defined what an unnatural death is. An unnatural death includes every case of death of a person which occurs suddenly, violent, or in an unnatural manner, or where a dead body is found, or where there is reasons to believe that the person died from in a suspicious manner, or where a natural cause of the death does not arise, or where any person is responsible for that death of that person. For the last couple of months in Guyana, we have seen a number of outcries in relation to persons who have died by the hands of the police, and where there is confusion in relation to what is the course of action. I want to say clearly that as a citizen of this country, there is protection under the law where any one of us can report an unnatural death. Section 4 of the Coroner's Act says person or anyone who becomes aware of unnatural death shall notify it to a coroner or to the nearest police station. In this instance, let's say the death of a person is reported to the police station. What is the police responsibility first? The police responsibility will be governed under the police force standing orders. And the police force standing orders, if we look at section 4, deals with report of a natural death. Everyone who becomes aware of a natural death shall notify the coroner or the nearest police station, and they do so. This is the police responsibility. They will take that report, and they will take that report on a particular form, and that form allows for the police to write all the detailed information as to how the person who is reporting came into the receipt of the information, and of course they will say clearly where is it that the body was found and the circumstances under which they observe the body to be found. Now, more particularly, under the Act, the Director of Public Prosecutions, and this will be under, I believe, sections 22, under the Act, will allow for the Director of Public Prosecutions to make a request, more so Section 19 of the Act, in which the Director of Public Prosecutions can make a request that a coroner holds an inquiry or an inquiry as to the circumstances surrounding the death of a person. Now, interesting in relation to this act is that we have to be very mindful that the laws of Guyana have been compiled with some form of thought and intent. And I wish to draw a reference to the Coroner's Act where someone dies in custody, let's say in the prison or in the lockups. Now, the person who will be investigating that death or a natural death, according to the Coroner's Act, should not be a prison officer or should not be a policeman, or those persons should not sit as a juror inquiring into the circumstances surrounding the death of the person. Now, we can draw a very parallel understanding of the importance of that provision. For example, we had one incident in Essequibo of the deceased Boston. Now, of course, this is where an allegation was leveled that a police fired shots resulting in the death of the person. Now, there is provision in the law, and I believe this is how intentional the laws are, in that a police in itself should not be the person heading and investigating their own causes. And that is why there is need for this type of intervention and this type of revisit to our Coroner's Act, where we activate the provisions made under the Coroner's Act to have certain inquiries done by independent persons, an independent jury, an independent coroner, so that the circumstances surrounding the unnatural death of a person is properly ventilated with its highest level of integrity, and of course that the citizens are very much satisfied that justice has been served. In addition to what the explanation is in relation to the importance of an inquest being held by a coroner, is that you cannot or should not be an investigator in your own cause. This is a situation, we have faced a situation in Guyana in which there are multiple persons or police officers on a scene. No one wants to directly say who fired the shot. What are the circumstances under which the shot was made? There is a level of distrust. There is a level of uncomfortableness in terms of the manner in which the investigation is being conducted by the police. This brings us to the importance of holding an inquest and the provisions that the law has made for a coroner's inquest, in that all of the pieces, all of the investigation, all of the circumstances surrounding an investigation is now being channeled to a central independent group, the coroner and the jury, to determine whether there is any form of criminal liability for the persons or persons involved. I believe when we start to be able to have a revitalization of this type of operations in which the law makes provisions for, we are going to have a lot more matters in terms of police shootings, in terms of matters that we believe that the police have not investigated in a very thorough way. We're going to have a lot more trust and feel as though there is justice in a particular matter. Why? Because I believe our own people who are intelligent, and that's where the jurors come from, the citizens, our communities, those who are intelligent, those who will sit and listen to a matter, and those who will help to make a determination in relation to criminal liability is very, very important. Now, of course, the Coroner's Act is very expansive, very large in relation to the responsibilities of an matters of peace who is that is very important. Now, there is need for a very careful consideration to having an inquest into an unnatural death at a very early stage, and the law makes provisions for that. Why? Because if there is need for the jurors, as well as the coroner, to examine the body of the deceased, it's very important that they have enough time to do that, to make certain findings. These are all provisions. These are all provisions that have been there for a very long time, and these are things that we can use that will bring a level of satisfaction to our citizens, that of course justice is had in relation to certain matters and incidents that are unexplainable and unjustifiably done by the police. Now, under Section 20 of the Coroner's Act, the Director of Public Prosecution still has a role to play in relation to making a request that an inquiry, that there's further investigation in relation to a matter, and that there is a reopening of even a criminal investigations. It's important for us to understand that a person coming through a coroner's inquest can be charged criminally for an offense. Now, the provisions of the law is clear. If that person is somehow charged, let's say that person is charged for murder, and that person is facing the court where a preliminary inquiry is done, Section 21 speaks to that of the Coroner's Act, that of course the coroner's inquest can be stayed while the preliminary inquiry, or while the criminal proceedings is continuing in the magistrate's court. Not well. Stop a police offense. A person can still be charged with a criminal offense. Of course, the law does not envision that you have two parallel inquiries going on at the same time. One will be stayed, and in this instant, the coroner's inquest will be stayed pending the outcome of the investigation. Now, of course, the law says when an inquest should be held. All right. And when an inquiry should be held, the law makes the distinction of that. Now, just make a distinction for you. An inquest is where you have the coroner and you have the members of the jury, three members of the jury. The inquiry or the inquiry being held, that is only done by the coroner. All right, so the inquest and the inquiry is two different things, and we needed to make that distinction. But for this particular discussion, we're talking about the coroner's inquest. All right, where persons can be come to the coroner's inquest and of course give their evidence or give their information or give their statement in relation to their own knowledge in relation to a particular matter, and that is like an investigation all by itself. All right, that's an investigation. So we want to be very clear that a coroner's inquest can be synonymous to an investigation being conducted independently from the persons who have alleged to be involved in causing an unnatural death. All right, so recommendations are made, and recommendations are made, of course, to the Director of Public Prosecutions, either that a person is recommended that a person be criminally charged, or that a person that there is no evidence that the matter go forward in relation to an investigation. All right, so that, I believe, in a nutshell, is important. Witnesses, it is conducted just as a court. Witnesses must attend court, and if a witness does not attend court, of course there is law which says that that witness can be penalized, and the manner in which a witness is brought to the court, a witness is brought to the court by way of summons. If summons is prepared and a witness is notified of the date of the inquest, the time of the inquest, and the place the inquest will be held.